Hello, this is Steve RInka again from the RInka Law Firm. I'm doing my next video where we discuss how to serve a lawsuit. My previous video we discussed about filing a complaint which initiates the lawsuit, but that's just the first step in many steps that you have to take in order to get the lawsuit activated as well as get to a resolution, which is the ultimate point of filing a lawsuit, is to get to some ultimate resolution. Well, once you get the conformed complaint back from the court, as well as the summons, the civil case cover sheet, and any other accompanying documents, the next step you have to do is go and serve these documents on the defendant or defendants, however many there are. You have 10 defendants, you have to serve it on each defendant. The question I get posed to me a lot of times by clients is, how do you serve the defendant? Well, bottom line is, it's pretty straightforward. You have to serve them personally. What does that mean? You have to have a person, an adult, physically hand deliver the complaint and accompanying documents to the defendant. That way, the defendant knows that they are being sued. This isn't a game of hide and seek. If the defendant doesn't know that they're being sued, obviously they're not going to know they have to respond to a lawsuit. So the court puts it on the plaintiff to make sure the defendant knows. Now, like I said, the main way to serve a defendant is through a person handing the documents to the defendant. And this can be done either by an attorney or a process server or somebody who's unrelated to the litigant in the lawsuit. Namely, the person who filed the lawsuit cannot serve the defendant. If the person who actually filed the lawsuit is named in the lawsuit as a plaintiff serves the defendant, then that service is deemed incomplete and has no effect. There are ways, though, to avoid having to personally serve a defendant. The easiest way is to mail the complaint and accompanying documents to the defendant if you know where the defendant resides or their place of business, somewhere where you know that they're going to get the summons and complaint. There is a form that is available on the California Forms website. It's form number POS-015. It's called a Notice and Acknowledgement of Civil Receipt. And with this document, what you can do is you can fill it in, putting down your personal information in the caption, and then you fill in the date of mailing, as well as the documents that you're mailing with this notice of acknowledgement and receipt, and you put it in the mail and provide 2 copies, one for the recipient to sign and send back, and a second one for the recipient to receive. And the recipient in this case would be the defendant. Once the defendant signs this form, they are to mail it back to you, and then you file this with the court, and the court, upon receiving this document, will take it as though you have actually served the defendant. And the defendant, by signing this, also acknowledges that they've been served with the lawsuit. So now it's upon the defendant to respond to the complaint. With respect to the defendant, by serving it on here, they're acknowledging, yes, you know where I live, and yes, I'm not going to make you go and spend additional money to personally serve me. So I'm going to make it easy on everybody. We're going to assign this, give it to the plaintiff. Plaintiff files it with the court, and I will respond. By doing so, this gives the defendant additional time to respond to the complaint. Normally, you have 30 days as a defendant to respond to the service of a complaint. But by signing this, the court's going to give you some additional time to respond to the complaint, because you're doing a favor for the plaintiff, so it only means that you should get some sort of compensation, like any agreement, for being cooperative. Now, if the defendant doesn't sign this, even though you know that they received this document, and then you have to go and personally serve them or serve them through some other process, you can then go after the defendant and get the additional costs you incurred as a result of the defendant not signing this notice and acknowledgement of receipt. So, to do this notice of acknowledgement receipt, postage is maybe $1.50, whatever. Not a lot. Well, if you have to have somebody go personally serve it, that can range anywhere from $85 to $100 or more, depending on the circumstances. Assuming you use a service process company, which I do. Anyway, so you would then theoretically be able to get that $85, $90 back at the end of the lawsuit, presuming you prevail against the defendant because they failed to sign the notice of acknowledgement and receipt. So that's how that works. Now, many times when the defendant or when the plaintiff is going out and having the defendant serve through a process server, the process server will perhaps go to a house and the actual defendant is not home. And let's say some minor or somebody that lives in the house opens the door and answers the door. Well, the process server cannot leave the complaint with that person opening the door at first. That's important. The process server has to make several attempts at serving the defendant at their place of residence or last known address. But after the third attempt, then the process server can do what's called a substitute of service, which means they can leave the summons and complaint and other documents with the person that opens the door as long as they record the person's name or a lot of times the person answering won't give their name because they want to remain anonymous and not get involved, which is understandable. But the process server will then write down a description of what the person looked like, height, weight, hair color, eye color, very descriptive so that later on, if the defendant says, well, I never got served, the process server can say, well, I went to your house on such date, such time, and this person who looked like this answered the door and took these documents. Because once service is complete by the process server, they fill out a declaration setting forth the date, time, location, as well as who received the documents. And I've had situations in trial where they've called the process server in, going and describing who accepted service of the complaint. So this does come an issue, and service of the complaint is a very key part because this is the trigger that gets the lawsuit rolling. Now, there's, in addition to serving the defendant personally or serving someone at the location, in the instance of a business, obviously a business, they don't have a live person to serve. So who do you serve? Well, you have to go to the California Secretary of State website. And on that website, there is a link that says business searches. And what you have to do is you have to go to a business search. You have to put in the business name. A lot of times, too, businesses, they don't do their professional name or the name they put out in the public is not the name listed in the California Secretary of State. A lot of times they're doing it as a DBA or they're a subsidiary. So it may sound easy, but I've gone in there many times. I'll put in the business name and nothing comes up, and I'm like, what's going on? This is how they go and portray themselves to the public. How can they not be registered this way in the California Secretary of State website? Well, it's because businesses have a lot of things going on. There's, corporate law is very complex, and how businesses do business to the public is not necessarily how it appears on their tax form, which is ultimately what the form of business that is on the California Secretary of State roll. So what you have to do is find out the true native name of the business, type that in, and hopefully, and it should, as long as they're registered with the California Secretary of State, which any business doing business in the state of California has to register with, that name should come up. And what you do is you click on that link. It'll pull up the address of the business, where its principal place of business is, as well as where the proof of service is to be, or the agent of service is located. So what you would do is you'd have to put that name and address down and provide that name and address to the process server so they know where to go. And typically there's several corporations. CT Corp is a company that accepts service on behalf of a lot of corporations. They're an international conglomerate. They're a subsidiary of another corporation, if I'm not mistaken. There's also the CSC Lawyers, which also accepts service for a lot of corporations. So there's a couple of large entities that deal with this. And then sometimes agent for process for the corporation and the location, you give that information to the process server and they go ahead and serve that location. The process server fills out the declaration, gives it to you, you file it with the court to let the court know that the corporation has been served. Now, sometimes you just cannot find this person. I have a situation right now where I'm hiring a private investigator to try and locate the last known address of this individual that I'm trying to serve the complaint with. And it can be very difficult. People that know that they're going to be sued will do whatever it takes in order to avoid service, and that means literally going into hiding. In that case, what you have to do is make your best efforts, document all your efforts to try and locate this individual. When you have a good address, you go out there, try and serve the person. If they're not available, if they don't live there, if the person that answers the door has no knowledge of that person, the process server keeps notice of that, writes it down in the declaration. And at some point, after you've exhausted all reasonable avenues of trying to locate where this person is, you can then go and ask the court to do service through publication. And what that entails is, much like what it sounds, you ask the court, say, Your Honor, I've gone and I've made all these attempts. You lay out all the attempts that you've made to try and locate this person and try and serve this person. And based on all these attempts, this person is, in essence, in hiding and we cannot locate this person. Therefore, I would like to go and have this person served through newspaper publication. And when the court shows or looks through everything and says, okay, it looks like you've made reasonable efforts. Sometimes, not always. It's not a guarantee. You got to show the court that you've done what you can do to try and serve this person, because once you're authorized to do the publication by newspaper, that's it. If the person doesn't respond, then they essentially are going to be in default. And that is something I will talk about in another video, is what happens if there is no response to a complaint. So, assuming that you publish it in the newspaper, the plaintiff then will see it. Theoretically, you would think the plaintiff would get in touch with the opposing counsel, acknowledge notice of the lawsuit, ask for the service to be commenced, get receipt of the lawsuit, and then respond to the lawsuit. But typically, if they're getting notice through publication, there is a high chance that you will not hear from that person. But what will actually happen is you will put in the notice of publication ordering that person to appear on said date, time, and court location. And if they don't, then that's it. They are in default. And as I said, typically at this point, if you've exhausted all remedies and this person knows of the lawsuit, very high chance you're not going to hear from this person, and you'll proceed to a default, which, as I said, I'll handle in another video. So those are the ways to serve a party in a lawsuit. If you have any questions, you can call me at 310-556-9653. And if you have any further questions, you can leave them in the comments section or call me at that number. Until next time, have a good day.